is that petrol stations are now required to sell at least 6% ethanol or be fined up to $500,000 for each quarter, but with a power in the minister to waive this. This product, ethanol, comes from a firm. There's only one producer of ethanol, and this firm has provided significant funding to the political parties. I find that curious, but I also find the exercise of what seems to be a judicial power by a minister curious. I also find it curious that you should be forced to sell ethanol. Margaret, would you like to comment?
Thank you, Professor Flint. I too am concerned about the very clear lack of appreciation of the separation of powers that seems to be the norm now in the state of New South Wales. You think to yourself, does no one have any legal training? But then you see someone like the current Commissioner of ICAC who had legal training to the point of being on the Supreme Court bench at one stage, still operating as though she is a judge. She seems to have no concept that the body of which she's now in charge has no judicial functions. It can only make recommendations. But of course, with these things, the process is the punishment. But and of course, when you give to one such person or one such body all the powers of investigation, together with the powers of prosecution, and even the ability to make very damning reports about people, with great coercive powers and without ever having to afford anyone natural justice, we're in a very, very difficult situation. And I'm glad, Professor, that you... I'm glad that there... Well, I'm not glad for poor Mr. Keir, whom I've now come to know and respect very greatly, a great hero of our state, a decorated fireman with 40 years' service, who in his humiliation... because he's not a lawyer and didn't, as I had, the support of many lawyers, didn't have that anyone behind him to help him and say, no, stop them. He capitulated with this. He thought he must have done something wrong. This is what happens because ICAC rules by fear and means to. Because it's all in secret, you can't know what you're accused of. And so poor Mr. Keir, we lost the services of this great man. And then in the scorched earth policy that ICAC pursues, they have the temerity then to try to ruin him in his new position, in his new community in Temora. Just to blacken his name. It never stops. And it's a really wicked organisation now, because the culture is it's ironic in the truest sense. The word irony is bandied about, but it is such an irony that they keep saying we have to educate the people about corruption. If you wanted to show the public what a corrupt organisation is, it's ICAC. That's the blueprint. Don't tell anyone what they're accused of. Keep it all secret. And the worst thing of all, the thing that has been forgotten and buried, and everyone says of me, oh, she was right because the High Court, to which my family, not just me, my son and his girlfriend were dragged. We already having established our case in the Court of Appeal of New South Wales, we were dragged there. But it didn't end there, because ICAC's infallible. ICAC will not be stopped. And then in the most extraordinary thing that we had then was the retrospective legislation. The ICAC demanded of the Premier retrospective legislation, which was put through within a day, quicker than the greyhounds, quicker than anything you've ever seen, with bipartisan support, because both sides of politics have been neutered by this body. Everyone's scared. They think if they can get people's phones from going back for 9 years, then they've got phone calls with me with people who are now discredited. I'm scared about this. Everyone's terrified of these people. And but it went through. And so as after that, the ICAC, well, one person from ICAC, presumed to attend upon my boss, the Director of Public Prosecutions, and say, look what she wrote about you 4 years ago when you were buggering up a case in the Court of Criminal Appeal of a case she'd done. and she doesn't like you. We can get her. Why don't you charge her criminally? And this is to engineer a bias in him. So it's absolutely out of control. But they think they're a court, and they're not. They're part of the executive government. But the retrospective legislation effectively took away from all the other victims. I've met many of them now. Their right of judicial review, and no part of the executive government should be free of judicial review. In fact, the more power it has, the greater it needs to be contained by the courts. But this body has resisted it at every point, and I can't believe that it's all been forgotten now. Anyway, I could go on about this.
Thank you. Fred Nile.
I don't know much about petrol or ethanol.
Yes. If I could ask Fred Nile, are you not proposing some solution to this?
Yes, I've been a member of the Parliamentary Oversight Committee of ICAC since it was first introduced. In fact, I campaigned for it and for two bodies, a crime commission to deal with criminal activity and ICAC to deal with corrupt activity in governments and the public service and so on. And I thought they were two good pieces of machinery to have, but I agree with what's just been said about the abuse by ICAC. That's why our ICAC committee has recommended to the government that there no longer be just one commissioner who can sort of act sometimes irrationally. There'll be actually three commissioners, and the three have to agree in certain procedures. We hope that that'll bring some moderation into the operation of ICAC, but it's up to the government now to accept our recommendations and introduce legislation. We can't introduce a bill. That's the government's role, but I'm pretty certain that that will happen because our report was unanimous with members representing all the political parties, particularly the Liberal Party and the Labor Party. So there's no opposition to our recommendations, which covered a whole range of issues.
There seems to be a gap in the New South Wales Constitution, probably all state constitutions requiring bodies to observe the separation of powers so that bodies do not exercise judicial powers when they're not courts. And on a related matter, I'll come now to Peter King. Under the Constitution, the Federal Constitution, the Federal Parliament has power to make laws with respect to the acquisition of property, the taking of property, on just terms and for a purpose of the Commonwealth. There's no such provision in the New South Wales State Constitution. Peter King, you're a distinguished barrister and you're involved in cases on this. Would you like to speak to this, please? You may need to borrow the microphone from Margaret.
Thanks, David. Perhaps if I could just begin by thanking you and your staff for your commitment, intelligence and energy in putting it together today, and I'm delighted to be part of it. When it comes to property rights, the dubious proposition that I'm from the government and I'm here to help you is about as convincing as the proposition that the cheque's in the mail. It is true, as David has suggested, that Section 51(31) of the Constitution says that the Commonwealth, by its Parliament, for the purposes of the good order and government of the Commonwealth, is entitled to make laws which have the effect as follows. And perhaps I should read it to make sure that we get it completely right. The acquisition of property on just terms from any state or person for any purpose in respect to which the Parliament has power to make laws. So there's been a lot of debate about that since 1901 in the High Court and in other courts. But we can say for sure that a guarantee, that constitutional guarantee of just terms does not apply to the states. So that if the states take property, as they did recently with respect to, or attempted to, in respect to greyhound racing businesses and even tracks, then they didn't have to pay anybody. Theoretically, the Commonwealth would have to do so if they did. It's become academic in the state because the Premier has seen the wisdom of his turned his position about. So far as the Commonwealth is concerned, there's continuing debate in the courts as to what that proposition really means. So, for example, in the case that I think David referred to of Spencer, the the High Court held that Mr Spencer had an arguable case in relation to the loss of his land for the purpose of making it available for carbon credits under the Kyoto Protocol. The matter then went back to trial, but the trial judge said that yes, he had lost his land, but there'd been no benefit obtained by the Commonwealth, so therefore there was no quote-unquote acquisition, so that the constitutional guarantee didn't work in his favour. That sort of hair-splitting is a difficult problem in this area. That issue's gone on appeal at the moment, but as you can tell, the basic proposition is a good one. Nobody should lose their property except on just terms for any public purpose. That was one of the principles that Hume had in formulating the modern state, and long may it continue.
Thank you. And as you referred correctly to the greyhound ban, that provision, that legislation, contained a provision that they were to be stripped of any right to go to court to claim compensation. And there's also, is there not, a report by Mr Russell QC in relation to the acquisition of land, which relates particularly to West Connex, and he has suggested that there be reforms of the rate of compensation, but that hasn't yet been seen. A few years ago I suggested to the then, he was about to become Premier, Barry O'Farrell, that the Constitution of New South Wales should be amended to give a similar guarantee. He said that, it could be amended, but it then could be removed. It was a public occasion. There wasn't an opportunity to say, yes, but you could entrench it so that it could only be removed with a referendum.
Mm. Well, good point, David, and let's hope your advocacy on this prevails.
Yes. Thank you. We're going through these and we'll come back for questions. The next matter I wanted to raise was federalism, and a reading of the convention debates demonstrates that the federal parliament was conceived as a parliament of limited powers, with the other powers going to the states or to be exercised by the people of Australia. And it also, as you full well know, the Constitution says it can only be changed by a bill being presented to the people in a referendum. In the Cane-Toad Republic, a book I wrote at the time of the referendum, on eBay or any good second-hand store, I identified 9 subjects in which the people had been asked to change the Constitution on more than one occasion, even 5 occasions. I noted that all of these referendums, which were all defeated, as regards the transfer of powers of the Commonwealth, would no longer be necessary because the Constitution has been reinterpreted to give these powers to the Commonwealth anyway, so they don't have to ask us. John Stone, you've campaigned for many decades for the Federation to be restored. Where do you see this going?
Well, it's pretty hard to be optimistic, I have to confess, but still you have to keep your spirits up. Incidentally, this is something of a digression, but during the course of this morning, when Mr Fitzsimons was hectoring us, he asked people in the room whether they regretted the passing of the appeal to the Privy Council, and I was one of those reactionaries who put my hand up. The reason I put my hand up was this, that as people better qualified than I well know, one of the things that keeps our own courts honest, I'm not suggesting our courts aren't for the most part honest, they for the most part are, but one of the things that does keep them honest, or is at the lower level, there's only one court which is exception to this, is that they can, decisions in those courts, lower courts, can all be appealed to higher courts. One court to which that no longer applies is our High Court. I don't myself think it's coincidental that since the Privy Council appeals provision was repealed in, I think, about in 1986, we've had a whole barrage of absolutely unconscionable judgments from the High Court, I think beginning with the Tasmanian dams, worst of all, Mabo. Absolutely. I mean, can you imagine the Privy Council even countenancing what was decided in Mabo? They would have thrown it out in 5 minutes. And so that I think is a loss to our constitutional situation that we no longer have an appeal to an outside authority for our highest court. Now, back to your point about federalism. Tony Abbott, of course, when he came to office, had written a book called Battle Lines, in which he took some very unfortunate views about federalism, I'm sorry to say. But he did, however, during the course of his time in office, I think change his mind. In fact, he had, I think, changed it by the time he came to office, because he produced a revised edition of Battle Lines, which really reversed himself on a lot of the federalism aspects of that original book. And he was in the course of, or his government rather, was in the course of producing a federalism white paper, which, following the coup of a bit over a year ago, has fallen into the rubbish bin somewhere in Canberra, and we no longer have that particular hope for us. The things about federalism are quite sort of basically simple. You should not be having decisions taken, as far as possible, by people who are far away from where they're being applied. And that's why we should be having decisions on things like education, health, and all sorts of other subjects, which really are all within the provinces of the states, why we shouldn't have decisions on those matters being taken by the federal government. Because, I mean, having spent 30 odd, well, not actually 30 years in Canberra, having worked for 30 years in with the Treasury, 21 of them I think in Canberra, I know a little bit about the attitudes of people in Canberra, and they are not really sympathetic much to the views of people in state governments. They think they know better for the most part, and of course, since they have the money power behind them, their views usually prevail. So I think that while I don't for one moment think we should give up the cause of federalism, I have to say, if one's realistic about it, that for the moment at least, I don't see Mr Turnbull at least leading a crusade to reverse the federalist trends.
There was a report a few years ago by Anne Toomey and a law professor, an economics professor, I can't recall his name, but they demonstrated by surveying the situation across federations that the more truly federation a country was, the more it increased its income. And Switzerland is the classic example, a country with no resources, which has a much higher GDP per capita than we have.
That's quite true. Could I also, just by way of addendum, say that we've had actually in the High Court, let me say something kindly about the High Court now. In the High Court, we've had, I think, 3 decisions in the last, 6 or 7 years, which go to my point of view, put it that way. First of all, we had the famous Pape case. Then we had Williams 1, as it's called, which was the so-called school chaplains case. We subsequently had Williams 2. Now, in all those cases, the High Court, particularly in Williams 1 and then Williams 2, the High Court made it very plain they believed that the federal government had gone beyond its powers by bringing down legislation in sort of one-line appropriation, one-line provisions, one-line items in the appropriation bills, even though there was no federal purpose to which those appropriations could be attached. In other words, they took the view that because there was a line in an appropriation bill, which of course is a federal act, that therefore it was okay, it was legal to do it. Oh, thank you. But the High Court made it plain, and they set out a long schedule to their judgment in Williams 1 particularly, saying that, in all these cases, we believe these decisions have been unconstitutional. So what did the federal government do? This was, I should say, the Gillard government, I think, at the time. They purported to pass a validating act, which I'm sure, had it been appealed to the High Court, would also have been found unconstitutional, but it's not been done. So, and they did it again. They reiterated their views in Williams 2, but the then government, the Gillard government, and its successor governments, the Abbott government and the other term, have done nothing about reversing that situation. And this is, in my opinion, a public disgrace.
Thank you. Peter Manuel, are you here? Could you raise your hand? Peter, could you give a microphone to Peter Manuel, please? The next, excuse me, the next matter I want to raise is water rights. 1/5 of the time at the 19th Century Federation Convention, 1/5 of the time was spent on water rights. It was very important, especially in relation to shared rivers, as you can imagine, the prime example being the Murray. now under the Murray-Darling Basin Authority. Section 100 of the Constitution seems to be very clear. The Commonwealth shall not, by any law or regulation of trade and commerce, abridge the right of a state or of the residents therein to the reasonable use of the waters of rivers for conservation or irrigation. It seems to give a guarantee to a reasonable use of the waters of rivers. However, the courts have interpreted that as being subject to other powers of the Commonwealth, and in particular the external affairs power of the Commonwealth, which relates to applying international conventions and the like. There's enormous upset across parts of New South Wales in particular, and other states, in relation to the Murray-Darling Authority and the way in which water is allocated and the way farmers feel themselves, and I'm sure they are, persecuted by the authorities in relation to water. We actually have a farmer here today from South Australia, Peter Manuel, and I'm wondering if he could tell us some of the problems, the real problems, that a farmer has in Australia these days.
Thanks very much, Professor. Look, I represent, or I'm the head of an organisation called FLAG Australia, Food Producers Landowners Action Group Australia, and we are very, very concerned, amongst other things, but about water rights. And if I go back in 2004, under the National Water Initiative, with our current Prime Minister, who was then Minister for Water, Malcolm Turnbull, separated water from land and made water a tradable commodity. And now we've got a situation where we've got over $50 billion worth of our water rights have been sold to overseas investors. So we've got a situation where I've got a Pole Hereford stud in South Australia, and I'm not allowed to irrigate, and now we are getting charged a right to take water levy on our farms if you've got a water licence, whether we use it or not, and it's based on our capital value of our properties. We are now an endangered species, believe me, and the amount of people that I get phone calls, farmers that want to take their lives because their businesses have been taken away from, is astronomical. We've got 4 farmers a week committing suicide in this country, but all of a sudden we see a beached whale, and of course it's on every page of every paper in Australia, but we don't see anything about farmers committing suicide. I had a situation where I had a young fella ring me up, and his name's Tony Willsmore, and I met him at Woolworths in Strathalbyn, my hometown. And he said, Peter, he said, I'm going home, they've taken my water, I'm going home to load up my chimney and blow up my house. And I said, no, you're not. Anyway, he went to all the politicians, couldn't help him, went to the mayor, couldn't help him. Anyway, I got all his water back with the flick of a pen. The reason I did that was because they hate my guts. And why do they hate my guts? Because I get on radio and I will expose these people publicly. And that's what's got to happen. I just want to say before I go any further, it's a credit to you, David, and Jai with the Australian Constitutional Monarchy. What you've done here today is brilliant, and thank the Honourable Fred Nile for allowing this. But I won't take up too much time because I know you're pushing for time. But in all honesty, we, the mum and dad farmer, are an endangered species. And we've had the privilege in our lifetime to eat clean, healthy food for all of us. And we want to protect that for our future generations. And the only way we're going to do that is to get out of the United Nations. We have got to get right out of this. We have got to get right out of this non-elected committee. We need to govern in our own right, and water needs to be restored to land. Thanks very much, David.
Thank you.
David, can I just add one thing
Yes, certainly,
that Peter's just said? It's time that those water rights that you referred to in Section 100 of the Constitution are treated the same as property rights, because water is as valuable as the property upon which it's found.
Thank you. The Minister for Water at the time was Malcolm Turnbull when those provisions were introduced. Now, obviously there needs to be a reconsideration of Section 100, and I am told that this will be something which one of the new political parties in the Parliament, the One Nation Party, are going to make a particular cause, and they will push some new respect for Section 100. The next matter, and I'm just listing these matters, is Ian Warner here? Yes. Could the microphone go to Mr. Warner, please? Thank you. And I wanted to raise now Brexit. At the time of Federation, there was a parallel movement. There was a Federation of the Australian colonies, but there was a parallel movement for an imperial federation, that of the United Kingdom and the Dominions and the colonies, into one single entity, which never took off. But the decision of the British people to choose to withdraw from the European Union means that Britain returns to her full status as a full country. She returns really in her relationship to the realms as she used to be, the Commonwealth, the special relationship with the United States, and to the Anglosphere. Will this have, do you think, and Mr. Warner may wish to comment, will this have an impact on our intelligence exchange, on our defence trade, and the movement of peoples among the countries of the realms and the Commonwealth and of the Anglosphere?
Well, Mr. Chairman, I was talking to the Professor earlier over the weekend about this matter. In my view, and I've sort of read fairly broadly, etc., I think there's far too much of a trend to diminish anything that's English. We downgrade it. English are no good. It seems to me that when you look back... Is your mic on?
I think you have to hold it.
Hold it a little different angle.
Is that better?
Yes.
Right. It seems to me, from my reading, that when you consider it, the British Empire was really the greatest institution in the history of the world, far greater than the Roman Empire, for instance, which was only around the Mediterranean. The British Empire was the first real world empire, and also Great Britain was really the first undisputed world leader from 1814 onward. And but it seems to have lost its way to some degree, and it does seem to me that Brexit is an ideal opportunity for Great Britain, to reassert itself. And there's so many people who thought that the UK didn't count anymore, and that seems to be dismissed because there's been enormous world comment and concern, particularly in the United States, about Britain leaving. But the UK is no more a part of Europe than is the United States, except it's closer. That's the only difference. UK institutions are very different from Europe. Its parliament, hundreds of years of unbroken tradition, only the 1660s when they tossed out King Charles, etc., and the Dutch helped there with the establishment of the Bank of England, etc. When you look at Europe, France is on its fifth republic, which from memory commenced in 1958. Germany, the same. Its present government only dates back to 1960, something like that. So I do think that Brexit will work, provided the English world works, because I think that in many respects England has become somewhat of a lazy, sooky country, like Australia. And so the key to it, in my view, is that it'll work if the Englishmen really get down to working hard. And Margaret Thatcher rescued England from a real downward trend, and I'm just hoping that Theresa May continues on in that role. After all, the English world has had a great tradition of these leading English ladies, from Queen Elizabeth and so on and so forth, Queen Elizabeth I. So I think it's just got to get rid of its sooky mentality and reassert itself. The only reason for the UK remaining in the European community really is it is the only nation which could curb Germany, and always the great fear is that Germany, which is really one of the most powerful, significant, well-disciplined nations in the world, could feel it reasserting itself when it doesn't have England to restrain it. But nevertheless, I think England can still restrain it, even if it is outside the EC. So I'm very strongly in favour of England taking a risk and exiting the European community.
Thank you. And the next more constitutional issue relates to freedom of speech. 18C of the Racial Discrimination Act is all in the new. It makes it an offence to, or rather unlawful for someone to do an act that is reasonably likely to offend, insult, humiliate, or intimidate on the grounds of race or ethnicity. What I'd like to ask, perhaps the Margaret or Peter, is this constitutionally valid? Does it go too far in relation to the Convention on Racial Discrimination? Seems to me that it does when you read the Convention. Does it somehow breach the freedom of political communication that the High Court has found in the Constitution? Would you like to express an opinion on that?
I'm happy to do so. Look, I think it does, but it's probable that not all four elements of the provision to which you've referred to breach the implied freedom of political communication. However, the question as to whether or not a particular statute and another does actually breach that implied freedom is one of some complexity. There are about 4 layers of issues which the High Court has recently identified in the New South Wales Union's case and then in a more recent decision. But there's another provision which is rather similar at section 47ZQ of the Anti-Discrimination Act, which makes it an offence to criticise anybody on the ground of homosexual vilification. So that, and there's an issue that's coming up in the Court of Appeal in New South Wales on that same very point. So we'll see in the next few months whether or not 18C is valid or not, David.
Thank you. And the final matter I wanted to raise is politicians and accountability. The Australian Constitution was in part influenced by the Swiss concept of direct democracy. That's where the referendum comes from. We restricted that to constitutional changes. The South Australian Premier at the time, Charles Kingston, developed a proposal that there be a cooling off period after a bill had been passed by both federal houses. And that would allow for a time in which the citizens or the states could initiate a referendum. Alfred Deakin talked him out of this on the basis that the Westminster system would ensure that voters would select the best representatives on merit. He obviously didn't think of the power brokers, and he didn't think about how the two-party system would solidify. In the last election, we saw a distinct move away from the major political parties. There seems to be a widespread discontent with the politicians. And I'm going to ask Jai Martinkovits whether you're in favour of some ingredient of direct democracy in the Constitution. What do you think could be a solution to make our politicians more accountable?
Well, when David was introducing the panel, he probably could have more appropriately said a panel of eminent Australians and Jai Martinkovits. But to offer a few comments on the issue of direct democracy, it's certainly something that I think could be explored in greater detail. As Professor Flint has alluded to, we do have, through the referendum provision, aspects or an aspect of direct democracy already. So when our Constitution was being drafted and approved by the people, it couldn't have been foreseen the state that we'd find ourselves in now, where the politicians really have afforded themselves a whole range of financial and other privileges. For example, special exemptions from the Privacy Act, where they can hold information and use it in certain ways that, for example, you couldn't, or an Australian business couldn't. So in return for these special privileges, shall we call them, there's certain measures which we've detailed in a book that we co-authored, David and myself, called Give Us Back Our Country, where we believe that the politicians should be, well, two things should happen: that the political parties, in exchange for those privileges that they've afforded themselves, should be required. It should be legislated that they be required to be open, internally open, democratic and transparent. So when we have pre-selection processes, and a small number of people are able to deliver and install candidates who aren't necessarily selected on merit, that's an unacceptable, in my opinion, situation. The other thing which we could explore to introduce tools between elections to make the politicians truly accountable, not just every 3 or 4 years where we give them a blank cheque. We can explore these in a little more detail. The measures that we could explore would be recall elections. So if there's a member who is underperforming in certain areas, or maybe in the case of, for example, a Craig Thompson overperforming in other areas, the people of that electorate may choose to recall that member to an early election. And also dealing with legislation, both legislation that has been introduced to repeal it by popular support, and on the flip side, where politicians don't want to touch things that are important to the people, why shouldn't they be able to introduce that as a law themselves by popular support?
It's worth noting, isn't it, that there are two political parties that do propose this, two parties that have representation in parliaments. There's the Christian Democrats
That's very true.
in New South Wales, and there's One Nation federally.
Yes.
They both